In clause 27, Amendment 108, Lord Moynihan of Chelsea.
My Lords, I apologise for being precipitate. I was trying to get you all home as quickly as possible. I rise to move Amendments 108 and 109 in my name. My declaration of interest is that I've worked in my career with hundreds of companies, many of which had to create redundancies at one time or another, a few of which had to go into liquidation. I am not an insolvency practitioner. The first of these amendments, 108, is a small but very important proposal. First on it, a disclaimer. I'm not seeking to alter the vast majority of what is proposed under Clause 27. Only that small minority of redundancy cases that occur when a company goes into insolvency. Also, I'm not proposing any override of TUPE legislation, in particular in so-called pre-packs. What I am proposing is that on a non-partisan basis, we take advantage of the passing of this bill to rectify a long-standing conflict between two separate laws, a conflict that often places insolvency practitioners in an impossible position. What is this conflict, my Lords? It is between the provisions of the 1968 Insolvency Act versus the 1992 Trade Union and Labour Relation Act, which latter act, as your Lordships know, today's bill seeks to amend. The conflict has long existed. It's not a function primarily of this bill we're discussing today. Let me explain briefly what it is. Insolvency practitioners are required to act quickly so that value is not eroded. The 1992 Act, however, requires consultation of between 30 to 45 days, which would utterly frustrate the imperative to move swiftly. So the liquidator is basically required to break one or the other laws, and always chooses to break the 1992 law, and will choose to break it as amended by this bill, because the liquidator has to act speedily, and a long consultation, whether 30 or 45 days, would be impossible, is always found to be impossible. As a result, ambulance chasers write offering, quotes, free money to all employees because the law has been broken, and therefore the provision comes in that penalty money should be paid to these workers. This does not happen in all cases, only when trade unions are involved or the insolvency is large enough for the no-win, no-fee crowd to move in. Much of the money in bankruptcies then ends up in the hands of lawyers rather than any of the creditors. Note that in most non-liquidation situations, these stringent provisions make such such penalty awards rare. An employer would be foolish to flout the requirements only in liquidation, where the liquidator is essentially forced to choose to flout one law or another. Allow me, my Lords, to offer here briefly the relevant background to that important national institution, the Insolvency Service. In the UK, there are around 1,500 insolvency practitioners, but only some 800 of these actively take appointments at this time. It is one of the most highly regulated professions in the country. It has one of the most difficult exams to pass. So, to take the most recent example, in November 2024, of 172 applicants sitting for both exams, only 10 of them passed. And partly because of this, more IPs are retiring each year at this time than are qualifying. Now, my lords, insolvency professionals have to be a very tough-minded and resilient crowd, because of course it's always difficult to deal with the harsh realities of insolvencies. And there are many bad actors in this space who go to great lengths to frustrate the insolvency practitioner. They take personal suits against the IP. They make multiple complaints to the professional body to try to divert the attention of the IP. There are long, drawn-out wars of resistance from those trying to resist bankruptcy. IPs, finally, have very few funds with which to pursue the bankruptcy, let alone defend themselves against these depredations. So we need to ensure, my lords, that we protect this important national institution. We should seek to make their life easier and more sensible when lacunae such as this are discovered. We need to understand that a collapse in this institution could create chaos in the corporate landscape, with a free-for-all, with lawyers, creditors and bailiffs running riot. That well-known book, Why Nations Fail, points precisely to the collapse of institutions as the cause of national decline. So then, let me give the recent go-centric bankruptcy as an illustration of the precise reality of what happens in real life, rather than the imagined situation that governments have been persuaded will be the case. Go-centric, a Glasgow company, went bankrupt, owing some £5 million to employees, to HMRC, to trade creditors and others. £600,000 was owed to employees in redundancy, sick pay and so forth. £637,000 were available, so the employees received all that they were due. But in doing this, there was no consultation, so immediately ambulance chasers wrote to these employees saying, we've got some free money for you here if you take, actually the government, to the employment tribunal, which they did, and the employment tribunal awarded the 90 days penalty money, which is the maximum then that could be awarded, another £600,000 for these employees. Governments are told that there will be mitigation by courts, but there never is mitigation. No one came to argue for mitigation, not the redundancy payment service, which had to pay the money, and certainly not the insolvency practitioner. It was not their concern. HMRC, via the redundancy payment service, was therefore out by £600,000, and that meant in the end, the taxpayer was out £600,000. With Clause 27 of this new bill, this taxpayer-funded amount would rise to £1.2 million. Note that this is on top of the £600,000 that the employees received in redundancy money. And it's really the only occasion when this would happen, because no employer would be so stupid as to incur these fines, only in a redundancy where it is necessary to go against the law, as I've explained. Now, my lords, I have no personal interest in this matter, but looking to get a bipartisan solution, I wrote to the Noble Lady Jones, the Noble Minister, reviewing this dilemma, and she very kindly, as indeed she's done throughout this whole period, offered to meet, met with me along with the Noble Lord Leong and the Noble Lord Cates and others, and subsequently sent a written response to my letter, which made it clear that she recognised the problem but felt no change was needed. In particular, her response stated, consultation could still, she felt, take place. Secondly, in the law, employers are allowed flexibility, and courts will take that into account to make smaller awards. What she called the redundancy, her letter called the Redundancy Protection Service, it's actually the Redundancy Payment Service, will cap payments at 8%. So it was a kind and thoughtful response, but the response seemed in several places to conflate insolvency practitioners with employers. The two are very different things. The liquidator, for example, usually has no prior knowledge whatsoever of the company they deal with. Some half of the letter talked about employer obligations, but the employer is no longer involved once a liquidation is called in. In any event, this response, as I discussed in the Go-Centric case, did not reflect the reality of what actually happens in a liquidation. The insolvency practitioners have no reason to spend money attending employment courts. Much the same is true for the redundancy payment service. So at the employment court, it is a free-for-all between the activists and the ambulance chasers. Whether because of this or not, I am told by insolvency practitioners that none of them have ever seen less than the full 90 days, soon to be 180 days pay, awarded on top of redundancy money. I cannot but believe, my lords, that this is just a mistake. The situation is complicated by the creation of the new Fair Work Agency, and I believe it's poignant, my lords, that we are discussing the creation of a new regulator the day after the Chancellor of the Exchequer described regulators as a boot on the neck of business. Does the government at this end of the House talk to the government at the other end of the House always? Will the new regulator make the situation even worse for insolvency practitioners? I ask the noble Baroness, the Minister, to give assurances that this will not be the case. So, to summarise, my lords, my amendment merely seeks to carve out insolvency situations from clause 27. The liquidator will then not have to break the law will as a result reflect reality, and the large majority of redundancies will not be affected. Finally, while on my feet, I also, my lords, need to move Amendment 109. In doing this, very briefly, I feel myself to be acting on behalf of the government's Chancellor of the Exchequer, who, as I mentioned, said yesterday that regulation is a boot on the neck of business. So instead of having clause 27 worsen the burden of business, increase the pressure of that boot with its 30 to 45-day delay before dismissals can take effect, I propose that the delay be reduced to 21 days. My lords, I beg to move amendments 108 and 109.